If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing, there's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else, then propose it.
Orally or in writing? Is the court mind oral?
Sure, go ahead.
You are to disregard any commentary, any comments that you deem commentary on counsel for either side.
So instead of disparaging?
Yes, that's assuming that there were disparaging.
Well, that's why I'm saying that may have been. So that may have been commentary? Well, I mean, right. It's irrelevant whether he said, you are doing a fantastic job today either. So, all right, maybe craft it a little bit more, and I understand what you're saying. So if you want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
It should be disparaging.
It might stay like that, but
I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about the Judge Glanville has been removed.
okay.
Other than that.
All right. Okay, so we'll leave that for now, and if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
Yes, Your Honor.
All right, thank you. Okay.
Excuse me.
Yes.
May I bring up a brief issue? Before,
Absolutely.
You continue. You mentioned this morning about that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on Odyssey. I haven't received any of the submissions from Ms. Steele that came through Odyssey. I know I've talked to several other counsel, but I haven't polled everybody.
Okay.
So I don't know what the issue is, but I'm not receiving.
The issue is Odyssey.
Okay, yeah. So given that I can't investigate that today,
And I can't do anything about that. I mean, Odyssey. So,
you can email the rulings out.
sure. And I mean, usually, at least the lawyers seem to get things fairly contemporaneously. I know the court doesn't always get things contemporaneously, but, and it sounds like some of the lawyers have received rulings. I know Mr. Steele received some because he filed a petition for a certificate of immediate review about 5 minutes after I filed one of the rulings as to one of his motions. So I don't know what the vagaries of Odyssey are and why sometimes it seems instant and sometimes it doesn't. But yeah, I don't have a problem with, as I file orders, emailing them out to everybody, just like I ask that y'all email me with your motions and responses. So sure, we can do that going forward. Okay. You're exactly right. Yeah. Okay. So yeah, and I do not think that we have been filing our orders in everybody's case individually, every co-defendant's case individually. I think we've been filing them, like, for instance, if Mr. Kendrick files a motion and I'm ruling on that motion, I understand y'all have all adopted it unless, you say differently. But I think we've been filing it into Mr. Kendrick's case. And so that is exactly right, Mr. Sharp. That's what's been going on.
Yeah, for some reason, previously we were receiving.
Okay.
So I don't know what's altered, but
Well, maybe what's altered is that somebody on Judge Glanville's staff was individually filing it in every case, and I haven't been, and the clerk's office, I guess, hasn't known to spread it out into the other cases. So that's what's going on instead. Okay. All right. Thanks for bringing that to my attention. All right. So are we ready with any portion of Mr. Kendrick's testimony? What did I say? Copeland. Yes, Kendrick. I said Kendrick. Yes. Are we ready with any portion of going back, either any kind of agreement as to what's already been testified to, and if y'all haven't been able to do that yet, then, you know, hashing through the evidence that we're going to have to face again?
So, Your Honor, there's several statements. I think what's really helpful is when we have, and we do have some of the transcripts now where we argued, so that can kind of prompt everyone's memory. And last time we had to go through all the contested segments. What we did is the state played them in court, and then we made our individual arguments. And now that we have the transcripts of some of the, regarding some of the statements, I think we're ready to do that.
Great.
And it's just, I'm just giving the court a heads up. It's going to be somewhat, we just got to plow through it. And myself and Ms. Hilton did the best we could to try to figure out where we were previously. I don't believe, for the uncontested issues, I don't believe the uncontested issues have changed at all. That's, I believe I speak for everyone on the defense that we haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues.
Okay. That works.
Do you have the ability to play the statements in court today?
Yes.
Okay.
Yeah.
And
And the other thing I was going to say, the January 11th is the first, January 10th going into the 11th is the first statement by Copeland, and logically maybe that would be the first one we review, but I don't believe that myself or Ms. Hilton saw a transcript of our prior argument of that one.
Okay.
So I would ask if we could start with the other ones first.
Yeah, that's fine. Yeah, I think there's still one day maybe that Ms. Weaver's working on, so that may be the day you're talking about. So yeah, we can start on whatever the next statement was. And are you going to be playing these through Zoom? So do I need to get on Zoom?
Yes, Your Honor.
Okay.
You do need to get on Zoom.
And do you have transcripts of the statements that are going to be at issue?
Yes, we do have transcripts. What I wanted to know from the defense, if there were any that were litigated that are agreed upon, because if there are some that were litigated that we don't have issue with moving forward, I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right. Do y'all want to take a minute and have that conversation?
Yes.
I think I can answer that. I think anything that was litigated before needs to be litigated again.
Okay.
And regarding the transcripts, Your Honor, June 10th, we have the same imperfect transcript, but it's generally gives guidance. For some of the other interviews, the state has a transcript. There wasn't like an official
All right, now,
transcript.
when you say June 10th, are you talking about his June 10th statement or our transcript from June 10th of this year?
June
You mean
10th.
his June 10th statement?
2015. The state produced a transcript of that, and you know it's not perfect, but it gives guidance, and we're working off the same transcript.
Great.
For some of the other interviews, the state made a transcript at some point. Maybe, I don't know who made it, but it wasn't disseminated to us, and we made our own transcript,
Okay.
so we have like dueling transcripts. Just
Okay, well, that's not for June 10th though, right?
No.
Okay, so maybe before we get to whichever statement has the dueling transcripts, y'all look at each other's transcript and decide which one you want to go by, or if some parts of it are better transcribed on one and some parts on another, combine them and let's get the most accurate transcript.
And that's why we were playing the states.
Sure.
I just wanted to give
Yeah, but
Judge Glanville asked for a transcript, and there wasn't a reason on the transcript.
yeah, and it's certainly a lot easier and frankly a lot faster with the transcript. So if there is a statement that I particularly need to see and hear the statement for the evidentiary determination I'm going to make, that's one thing. But if it takes me 5 minutes to read a transcript or 20 minutes to watch the statement, I'm going with the 5 minutes unless there's a reason I need to be watching the video instead, okay? Because, I mean, honestly, for most of these evidentiary issues, I'm not here like making a credibility determination. For the most part, that's for the jury. I'm here trying to decide, does this evidence come in under XYZ exception under the law, okay? However, right now I don't have any transcripts, so pass up whichever statement we're going to be looking at right now, if it's June 10th, 2015.
Can I email it to you? Like I don't have a.
Yeah, that's fine. In fact, we might have some transcripts of certain of the statements, so. Under what? Ms. Weaver provided our chambers with several of the transcripts of the statements that y'all had given to them, I guess. So I've got the transcript of that June 10th. And I actually have videos of some of his interviews too. I think maybe all of them, but some of them play under evidence viewer that y'all gave to me and some of them don't.
So, if you received 6 interviews, if you receive 6, 5 of the 6 are all evidence reviewer.
Okay.
And then the only one that's not evidence reviewer is the October 2021 interview.
All right. Okay. So I need to get on Zoom. Give me a second to do that.
And can I have the link as well, Your Honor?
Okay.
Your Honor, may I, excuse for a brief moment?
Sure. June 10th, 2015, statement of Mr. Copeland to law enforcement, and we're all working off of the same transcript, and you're going to play the video as necessary.
Yes,
All right. Ready when you are. With regard to whatever portions of this are contested, tell me where they are, I guess timestamp in the video, as well as what portion of the transcript, and then tell me what the dispute is, okay? Yeah, you can just come up here. Sure. And, Lauren, can you shoot email? Down in there sometimes. And if not, then we'll just.
Get let in to the admittance.
All right, tell me.
Yes, and Your Honor, just to orient the court.
Sure.
So the state had proposed several redactions of portions of the interview that we did not want played. And the defense, for certain portions, wanted that portion to be played through the state.
Okay.
It's the state's position that if we don't play it, and they choose to play it, they can, unless we believe it's inadmissible.
Okay, so with regard to any of those portions that you just think, they don't need to hear this, but the defense wants to play, I guess, have y'all talked about whether the defense intends to play it so that you can tell me whether you think it's inadmissible?
Yes, and
Okay.
so I just wanted to
All
orient
right.
the jury that that's
All right.
where we are. So with respect to the June 10th interview, the first section, I'll just go in chronological order, that there was an objection. The defense wanted to redact timestamp 1019 to 1011. And I guess I'll let defense counsel explain why they wanted
1019 to 1011.
101911 to 101941, which is page 61, line 22 of, beginning at page 61, line 22, through page 62, line 14.
Man, I need a go-to page number on this computer. So I don't have to just scroll and hope I get it right. All right.
Yes, sir.
Can you repeat what you said about this segment? Who wanted what?
This is a segment that defense counsel, you wanted redacted, but we objected to it being redacted.
Okay, so this is what you, because a minute ago you said stuff you're not gonna play, but the defense wants. So now you want this, the defense doesn't.
Correct, Your Honor. So the way that we had organized it initially,
I mean, if we're just gonna walk through the whole transcript and then, that's fine. That's fine. I just need to understand what it is.
yes, so this was a portion that the
You
defense,
want, the defense doesn't.
yes.
Okay, and that is, I know it's 101941, no, 101911 to 101941.
Yes, Your Honor.
Okay, all right.
And right now, it's starting at 10:18:52. Evidence reviewers, sometimes a challenge to get it right at the right timestamp, so we just bear.
All right, let me ask. So I had just said, I don't know that we need to actually listen to the video of everything. And I mean, I can read the words on the screen, so on the transcript. So unless we also, for some reason, I need to be hearing it out of his mouth. And if I do, and there may be times I do, then we'll listen on the video. But if I don't, I can read it.
So the state's position is we wouldn't hear from the defense, but I think it's inadmissible. So that's what we were waiting for.
Okay.
Okay, so just a little context, if we're just looking at the statement as my legal assistant failed to turn on my mic. If we're just looking at this, the transcript as context.
Well, no, let me stop you. If you, for a reason, want me to watch the video, that's fine. I don't have a problem with it. I'm just trying to be efficient with our time.
No, that.
You mean, let me tell you what's been going on beforehand. All right, sure.
So they were discussing beforehand the Lil Wayne bus shooting.
Okay.
In this discussion. And then Kenneth Copeland on line 9 of page 61 says they did it. Who is they? And they who? And he says, Shannon and them. So the first part of our objection is Kenneth Copeland giving information about the Lil Wayne bus shooting. What Your Honor needs to know from me about the Lil Wayne bus shooting is Kenneth Copeland, it's not been alleged at all that he was at Club Compound on the night of the Lil Wayne bus shooting. It's not been alleged at all that he was present, that he was there, that he had anything to do with it. So, and it is not at all clear. So it's clearly hearsay. There's a search for an exception, and I don't know what the source of his information is. There were, this was Wayne Carter is Lil Wayne, and when his bus was shot, there was all sorts of internet reports on gossip blogs and everything else, and there's just no way to ferret out what his source is
Sure.
to suggest that it falls under any hearsay exception.
Okay.
Now, I have in my notes on the transcript that page 61, lines 1 through 10, were not objectionable. That's what my notes said.
Okay, that's right.
And then
Hang on. Let's make sure that's right. That's right.
What line did you say?
62 lines 1 through 10.
So, Your Honor.
62 or 61?
Oh, well, 61 as well, both. It starts on line 11 or somewhere about there.
So you want to ensure that y'all are in agreement that 61 lines 1 through 10 are in unobjectionable?
And Your Honor, that will. We need 2 rulings before we can answer that.
Okay.
So, initially, that was the case. However, Your Honor, based upon, we filed the notice of intrinsic acts that we would need to hear if this intrinsic act regarding the Lil Wayne bus shooting, specifically as it relates to Shannon Stillwell, if that is able to come in, then we would want to play the portions page 61, starting at line 1. Also, Your Honor, depending on the court's ruling on co-conspirator hearsay, co-conspirator statements, we would.
Well, I can't just give you a blanket rule on co-conspirator statements. I have to know what the statement is.
Yes, Your Honor. So that would be my response to this question. What Mr. Shard just argued is that
He's not arguing anything right now. He's trying to make sure we're all on the same page. So
correct. And so what I'm getting ready to say is what Mr. Copeland is speaking with the detectives about, which is the Lil Wayne bus shooting.
Right.
This is information that the state believes he received from Demekion Garlington, a co-conspirator.
Okay.
And so we believe that this would fall under a co-conspirator statement as in furtherance of the gang. So because he's telling him about an act that occurred between these gang members, and to give the court a little more context, the Lil Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Lil Wayne, on an evening in Atlanta Several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus. What Mr. Copeland tells police is that Demekion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So that is kind of the context of that statement here.
All right, so what Mr. Shart was trying to sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
No objection of it coming in. Yes, we have no objection of it being played.
Okay.
Right, that was never an issue.
Okay, and it's still not. All right.
So, and I don't think we need a ruling on the intrinsic, I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's an intrinsic act, because it's pled in the indictment as an overt act.
Yeah.
Part 1, so
Okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demekion Garlington. There's 2 issues. A, we think he got this information from Demekion Garlington. I don't know where they're getting that from. That's 1, other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling the beans. So there's 2 aspects to that where the state, burden is on the state, and I just don't see them meeting it.
So, DK, I'm sorry, y'all. It's going to take me a minute to get all the names. DK is who in real life?
Walter.
And Mr. Garlington goes by D, right?
There's
Who is little D?
There's 2 little D's.
There are 2 of like lots of these people. Okay.
So one will be referenced as Little D from Mechanicsville, and that'll be Demekion Garlington.
Okay. So does he go by both D and Lil D?
Primarily Little D.
Okay, and he's Garlington, but he'll be Lil D from Mechanicsville.
And he also is referred to as Scarface
Okay.
in the indictment.
All right. And then the other Little D will be,
Quindarius Zachary, Quindarius.
and when they say Lil D,
From Cleveland.
Cleveland. All right. So we got
And they also call him Sick D.
Sick D, Lil D, or Sick D. And he'll be from Cleveland. Okay, thank you.
And Your Honor, it's not speculation that Demekion told him this information. On page 61, line 22 through 24, Mr. Copeland says, Little D, that's how I get all my information, through Little D. Which Little D? D ain't, and they clarify, he says Mechanicsville, which is Demekion Garlington.
Okay.
I'm just not reading it that way.
All right, let's see. So maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
And Your Honor, it's gonna start a little earlier. It's gonna start about 10:18:52,
Okay.
but we're gonna be listening around 10:19:12.
All right.
I think it I like it. It was on Shannon DK now. DK with DK right here for you. The last name, yeah. What about Libby? That's how I get all my information to Libby. We can't be. Yeah. See, he not gonna be able to tweet all day. Twitter, Instagram, this all he gonna do all day. I mean, he gonna be everybody. He miss everybody. Everybody. I mean, talk to him. You know what I mean? So I always say, hey, like I call you right now. If he don't know, he'll sit right and tell me what's going on. So, well, I'm made a deal about this, bro. If you know you didn't even plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Tick too. Shannon gonna kill Tick. Nah, do it. Why don't you kill Tick?
And I can replay it, Your Honor, if you need me to.
So, Your Honor, this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspirator state, in every case I've ever read involving a co-conspirator state, appeal, the declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder, and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting and who did it. They ask him, what about Lil D? And it seems, I'll concede, it seems they're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Meteon Garlington, I think. I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot. He gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Demekion Garlington told me, and I know you don't need an exact date, but Demekion Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect to hear, yes, Demekion Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then, of course, again, it's spilling the beans when it really comes down to it too, because there's no context that would would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, the context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination that it falls under 801 D2E, and of course the burden is on the state to arm you with that information.
Yes.
While you're reviewing this, with all due respect, I want to renew my motion for mistrial based upon the entirety of the record up to this point, I think it's impossible for you to parachute into this. I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I, want to clarify that. Everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we were replowing this.
No.
Go ahead.
Okay, but
yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling, and that's something for potential appeal. That's true in every case, and I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial. Or I find out as the motion is being presented. So, yes, it would certainly be easier if I had heard 6 months of testimony that came before this, but I don't think it is a basis for mistrial.
I disagree entirely. You would know the basis and the people's names and the testimony had you been the trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled. Mr. Steele.
As you're making this analysis under OCGA section 24-8-801
it doesn't really affect me in terms of my, it's still the same amount of headlines to edit.
I'd like the court to just denote that in a good case, but I think it's
okay,
Stafford, S-T-A-F-F-O-R-D versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa. 865 Southeast 2D 116 2021 case. And the reason, I'm listening intently, I don't mean to interrupt, but the state's belief of the law over the past year is that any statement made by a supposed co-conspirator to another co-conspirator who speaks with the police furthers a conspiracy. And as Mr. Sharp said, that is just spilling the beans unless it really does something to promote the conspiracy. So even what the state just said, I get my information from Mr. Garlington.
I will look through the full screens, then I will watch
my point is
our
that
clips
doesn't help
and see
the
where I'd like it
state
to go, and
because
then I'll send you a
if
note
I'm in a
and
conspiracy
tell you,
with Mr.
hey,
Adams
edit,
to steal a
this
pencil,
one from this point to this point,
and I
put it
tell
over,
Mr. Adams,
that sort of thing.
I stole a pencil, or Haley, who I'd like
Yeah,
to
I didn't realize that.
stole the pencil
Yes, if you want to
as
come
part
look
of our
at
conspiracy.
you can come see.
Mr. Adams, then repeating that to law enforcement, doesn't do anything to assist them. Now, if he said, cover for Haley, give her an alibi, that is different. So the point I'm trying to make to you is,
People are just.
I'm not so sure that there
Okay,
is a conspiracy.
so
Like,
for this
I'm just telling you, I know
Saturday.
you're working hard.
So we have,
so I'll
these are the
appreciate it,
TV programs, right?
Mr. Nichols
We come out of
hasn't really
Sports
been
Talk, which
mentioned.
is TV, but also
not
Fox
mentioned in
Local.
opening
then we have our
statement.
Fox Local
He
only
has
program
one little
straight from that. We have behind
section
the scenes
on
with Paul Milliken.
I can't remember the
We didn't have
year.
casting call with Tess Hammock, so we won't, instead of
but I
live
don't know,
now, it'll be
small drug case.
casting call with
Otherwise,
Tess.
he's not mentioned.
Then we have Burgers with Buck.
And that, I'm
Then
not
we
trying
have
to
a
argue
new
for the
one
honorable
called Light and Sound
Trust
with
Form,
Eli
Mr. Harper,
Jordan.
but that's why he's always asking for 105
who is
instruction.
edited
The
this
point I'm trying to make
piece,
to you is
and we're going to go into
This
that.
exercise also has to
And then,
inject,
so
if
I'll
you
have
don't mind,
headlines here, here,
why
here,
the
and here.
state
It's
is
just my
saying it
tosses
furthers a
before, like my
conspiracy.
9
Just getting
and 10
information does not further a conspiracy. That's
Okay,
my point.
all good.
Thank you.
Thank you.
My 9 and 10 tosses will be the same, but 9:30, 10:30 instead of
Will be different.
live now and top stories. It's going to be casting call.
This is
and
not the
then,
only time in this interview that Mr. Copeland talks about the Little
What's
Wayne
happening.
bus shooting. So
I'm
this
like,
is
I knew we were
the
gonna add more, but I'm like,
first time.
Welcome to news, I guess.
He actually
It's
talks
us,
about
and
the
then, like,
details of the
I'm like-
shooting.
And then this last
done
one
it.
will have, this last one will basically be me just tossing.
yeah, that's the one I don't have to worry about.
At least
Yeah.
2 more
And then
times
here,
throughout
I'm
the
gonna-
course
I might
of this
put in a
interview.
weather
So this
hit
interview
for
is
Alex,
9 hours
but I
long.
won't do another.
And so in the course of that
headline.
interview, he gives more and more details about the
Yeah.
shooting.
So this
All right,
weekend,
maybe
it
point
will
me
be
to the
Paul
parts of
Milliken
that. So
on
yes, I don't know if
Saturday,
you were able
and then
to
it will be
pull
Joanne
up Stafford, or if you have it,
because he's out.
you know, if you've
So,
looked at
as a
it
result,
previously. But
Paul and I will likely do a talk back for 9:30, 10.
what it says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements.
Me either, just
And that is essentially that
just the two.
Yeah.
even where
And I
there
will- I'll
is
ask
a
Rob
conspiracy
or-
that
or
has
Rob
been
to
established by a preponderance.
But Paul's really great at helping and doing
Yeah.
stuff. So
No, I lost my
All
voice.
good. Like I said, I didn't know if my emails broke.
yeah, no,
'Cause it happened before I sent
Yeah.
one, and Andy's like,
I didn't get that.
when you send it? I'm like 5 seconds ago. He's like, weird. It shows like 3 days. I'm like, yeah. Like I said, that was
Here it
one of
is.
the- 'cause I
Hearsay
was
statements that
like,
implicate
hey,
a
this is something I
co-conspirator
could
but do
do.
not advance any
I
object
will
of the
watch
conspiracy,
casting call,
such
send
as
me the
statements that merely spill the beans about the conspiracy, are not admissible. So if you can point me to how this advanced the conspiracy, and I understand your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them, and that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy, and not theoretically where your evidence is going to show that.
Yes, Your Honor. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015 all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of two events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that. Evidence has come in that members of YSL, specifically, have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the two of them in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And we believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL like just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe that he was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we do not have any evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news, it promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across. It made headline news. It made news.
That may be. Again, how does then apprising Mr. Copeland of it further the purposes of the gang?
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
Promotes himself as YSL?
As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
No, we do not have any evidence of him posting on social media YSL shooting up the bus.
Okay. All right, so we are then looking at 61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So, Your Honor, then there's, and this is where I'm not sure what the state's 62, beginning of, I'm sorry, the beginning of 62, they just talk about Lil D from a Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong
No, y'all all said nobody cared if that came in 1 through 10. Nobody cared.
Yeah, 62, 1 through 10. I agree. I don't have a strong opinion. I was just trying to understand what. If the state had an opinion about that, or if all of that was coming out, or all of it was coming in, the 1 through 10 on page 62. I don't have an opinion.
No objection to it?
No. 62, 1 to 10, the state is okay with becoming.
Okay.
Okay.
I'm just trying to clarify something
All right.
else. But then, starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about potentially Jeffrey was going to have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is he entered a plea in this case.
Your Honor, that portion is redacted.
Okay,
62, line 15 through 22 will be redacted.
Okay.
All right. Next.
I believe the defense wanted next page 62, line 23 through page 70, line 16 out.
Tell me again, 62,
Page
line
62,
23.
Yes, line 23 through page 70, line 16.
16, okay.
Do we want to put up this hearing from Athens on a stream?
Which one?
The Jose Ibarra hearing, Lake and Riley.
Yeah.
It's supposed to be up on the switch right now, but it's not. I can help start it.
What time is it supposed to start?
I think it's supposed to start at 10:30. Let me go back to the email.
All right.
My recollection of this, and
11 o'clock.
Okay.
I'm not saying that the state's misrepresenting anything, but
Thank you, Joyce.
I don't think I
I
don't
shall wait
recall
then
having
to,
a blanket objection. Now, there's certain parts in this
but I'll put News 26
transcript
on
as a
stream
whole,
too.
and coming up not to 72, but a little bit after 72, that go back to the low wage bus shooting. And our stance is all that is covered under
That's why we
the
left
last
it
rule.
to-
I mean, all of it's
And then put down the vote on it.
the same general situation. But regarding these pages 61 to 72, what I have is I objected to 70 page
Dave stepped away, but when he comes back, he'll probably be able to put it back on.
page 70 lines 16 to 19, where it's just investigator Dennis identifying, it's not Copeland talking, but investigator Dennis says
If Shannon is a shooter.
Shannon is his, meaning Jeffrey's shooter. Why would he put these?
Yeah.
I think that's inappropriate to have investigator, just put that out there. And then after that, and then line 72, lines 5 through 13. Again, it's investigator Dennis kind of giving his theory on everything in relationship and meaning Kenneth, Jeffrey, and Shannon. And it's not needed to add context to anything. It's just kind of him giving his theory.
All right. So, does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16? Anybody have an objection to that?
Okay, I'm sorry. No.
Nobody has an objection. Speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, lines 17 through 19, we have no objection to
To
that.
redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, lines 17 through 19.
And also, I believe what he just said, page 72,
Lines 5 through 13.
no objection to that as well.
All right.
Oh, 72.
Not Gary going home. What?
Okay, next.
The next portion that I had initially was page 70. The defense wanted redacted was page 72, line 14 through page 73, line 21.
All right, does the defense still have an objection to that?
The 73 line.
No, 72, 14 through 21.
No, 72, line 14 through 73, line
Ah,
21.
okay.
God bless you.
No,
God bless you.
Okay. Anybody, any of the defendants have an objection to that portion?
Truth.
Sounds like a no.
Then you're on the next portion, I believe, would follow under your previous ruling, which would be redacted, which would be page 73, line 22 through page 78, line 16. So
Okay.
I don't think there needs to be any further
All
discussion.
right. Look at us making progress.
Your Honor?
Yes.
I briefly, having read Stafford, just to address something briefly related to the case side. Your Honor, in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police, and that co-defendant did not testify. So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Ken Copeland here on the stand who can cross-examine, so it's not what he said verbatim to Detective Dennis, it's obviously what he's stating to other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy, but that's not the situation we have with Mr. Copeland, who's live across the state.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you. All right.
Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a confrontation clause violation. What the
Right.
attorney is talking about.
But that wasn't what I was using it for anyway, so, yeah. Thank you. All right, so what's our next portion of this statement?
The next portion that we have, Your Honor, that the defense wants out is page 140, line 11 through page 143, line 16.
Ms. Hilton,
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, and I believe the full redaction that we agreed upon last time is correct. It's page 88, line 23 through page 92, line 20.
So y'all agreed that that's out?
Yes.
All right.
There's a small portion that we can play, which was page 91, lines 20 through 21.
91.
Line 20 and 21.
Everybody good with that?
I don't know. I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're going to do that? Well, they can figure that out. All right, so then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140 is the 112, 24 to 114, 25. We agree on that?
page 112, line 21 through page 114, line 25?
Yes.
Yes.
And y'all agree on that being out?
Out. Yes,
Okay.
Your Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being
I'm in concurrence. And then 129, I have 129.20 to 130.20 approximately.
I have 129, line 18 through 131, line 25.
Is out by agreement?
Out.
Okay.
131 line 25?
Yes, sir.
Okay, great. All right. I'm the same page.
All right, so now I'll read 140:11 through 143:16. All right.
So you're right. For this question, I want to give a little bit of a brief context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19th, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially, in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I wanted to give the court that context before we go into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19th, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19th, 2021.
Couple things. To the extent that shooting on February 19, 2015, where individuals shot at Kenneth Copeland. The story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child. He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It is no probative value to this case. My client, the fact that he is to be in possession of a gun, he's not charged for that. It's not this is an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, my understanding, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on first-hand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay.
And 403.
And 403.
So for relevance, Sharon, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leaves. So I don't think
that's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as relevance, Sharon, we believe that the simple fact that he gets the gun from Shannon, or it's Shannon's gun, that he has to shoot back at the opposition gang, shows one, that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does. As a part of their enterprise or conspiracy, they pass guns around. So we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022 is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value substantially outweighed by prejudicial effect.
Mr. Sharp.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. And this story, which really adds nothing to the state's case, you know, the idea, oh, it's evidence of passing guns around. I mean, they're going to have direct evidence of when Darius Zachary saying he's a straw purchaser of guns at Arrowhead Palm. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shmal Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just the
Okay, because
hearing.
it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland.
All right.
It seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that. What's our next section?
Well, if we can just, if up there, sorry.
Defense wanted out was page 188, line 9 through page 189, line 9.
But maybe then, I'll get to work. If you want to handle the YouTube, I can handle the Facebook. Sounds good.
Why did the thing say 11 o'clock?
I have no idea. But
I'm sorry, what?
no.
violate 404B, bad character evidence, and 403, Your Honor, as well. But then, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me it's getting paid nothing? D. So.
Well, no, then Kenneth Copeland says no.
I'm sorry. You're right. And then they just talk about
How Kenneth Copeland can't flex because he doesn't get all this stuff.
right, and how Shannon's broke.
Yeah.
So I just don't see the relevance of this. I think it reflects, it's speaking in very broad terms, and it's just broad bad character evidence about
Right, so it looks like Shannon told Copeland this, so it would be a party quoted statement because he says
Shannon told Copeland he doesn't get paid.
correct for the stuff, but what more importantly, not even to get paid or not getting paid, but that Shannon does anything Thug tells him to do.
No, the Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor. Let me be clear. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion of what he says in here, which is he does everything that Shannon tells him to do.
That Thug tells him to do.
That Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator, member of the gang, is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why in the gang.
I'm sorry, I'm not tracking, and I think I might be listening. Where are we getting the Shannon's?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video, he kind of whispers to him, and on page 189, detective says he said Shannon. Shannon's telling him, but you have to see the video to see it in context. So we can play that portion.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever Thug tells him?
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mm-hmm.
They have known each other.
Yeah, that's established in the evidence.
Established in the evidence. And so we believe that is his personal observation of what he notices between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So that's what we believe that's his source of knowledge. That's his lay opinion about what he's observing.
Anything else, Mr. Shart, on this?
No.
All right. I am going to permit this over the 401 and 403 objections. And I don't believe, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next one?
The next one that we have that the defense wanted out was page 202, line 14 through line 20.
And we are in agreement 197, 14, 199, 4.
Yes.
Did I get those? Did I get it correct? For your notes, the exact lines?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
202, 590.
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was going to say the opposite. Seems a little.
Dang. All right, well.
I agree with you, Ms. Stone.
Darn it. Okay. I'm just going to have to get a fan up here. Well, it's not up here. Okay.
And Your Honor, heat does rise, so it may be hotter up on the bench.
Okay.
Your Honor, since we called it higher elevation, we have a test.
Yeah, we can have a convenience break. Sure, let's break for until 10:30. That's down as far as it'll go. It needs to be adjusted.
Let me see when this whole thing is going to happen.
I don't know. Yeah, listen, I was listening to YSL.
Because like the guest was doing her makeup and she locked the door and like opened it, so it locked from the outside. But Aaron said she'll get someone to open it.
Okay.
I told her it's not like past that time.
No, no. It's not urgent. For sure. What did they go on break for? They missed that. Oh, I can go listen to it and figure out what happened. Because YSL's on break, apparently. I don't know why. Oh no, we missed the whole thing. We started at
Stop.
well, Dan and I are screaming frantically to get it up just as the
What are they doing right now? It said 11 in our thing. It's like a back-to-back.
YSL's on break, but I don't know why. Especially if you like see them.
Do you want me to go back and listen?
No, that's what I was doing. I found her to do it again. Except for the judge apparently is hot. She was complaining about the heat.
What part of the people's house? Normally people's house. That's what I was saying
It
about
sounds fine to me.
Really?
Yeah.
Okay.
I don't hear anything.
Hold on, let me try something. Do you hear anything?
Here's fine. Yeah, you listen to it because it sounds fine to me. It's perfectly clear. And believe me, I can't hear. I'm half deaf.
I'm wondering if there's like they're adding in.
I'm gonna ask. Why is there other topic?
Okay, I might have fixed it.
This is weird. Christine.
I'm wondering if it's picking up from those two nights on the desks. And then it's like, because that happened once before, but I just changed it. This is weird.
Well, you still here, Tom?
Okay. This is why I had it on a mix before, because, but they changed the mix for broadcasting on weekends. One of you got a what? Someone's like, Fox, when you got a wire on it.
Okay.
Start talking. Okay. Testing 1, 2, 3.
Oh my God. Yes. Talk some more.
Testing 1, 2, 3.
Because it's a delay.
Page 204, lines 14.
202.
That's right. That's right down at the 202. All right, so I'll entertain the argument against that.
I have 5 That is my objection.
If you're amending what you did before, that's fine, but before I have, for you, page 202, 14 through 20, but you're saying it's.
I have 5 and 19 in my notes, but either way.
Okay. 202, 5. Okay.
It's just a off the cuff, not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot at them, and then Kenneth saying Shannon doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. Get into arguments with people and they shoot at us. Again, not talking about a specific act. Just generally, and Shannon ain't going for it when people shoot at us. I mean, all of this is just.
All right, so let's kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but what I'm saying, me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say, I never did shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay.
Yes.
And
so we believe that that's relevant, that furthers what he just said earlier in this interview about Shannon not liking the fact that he was not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309, Georgia, 15. which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abuses discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what they cited.
309 Georgia
15.
Yeah, I mean, is it basically just for the proposition that owning guns and having guns isn't character evidence?
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your Honor. And so the fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court, Your Honor.
Anything else, Mr. Sharp?
I'm trying to look at Lyons real quick because I have a suspicion.
You have
Lyons a convicted felon?
Your Honor, I don't know if Lyons was a convicted felon, and I have not found a case in which the court distinguishes if an individual is a convicted felon, that imputes more bad character than not. And I don't know if that's the argument that Mr. Sharp is about to present to the court.
Well, okay. So I'm reading Lyons very quickly, but it seems that in Lyons there was an argument that the gun in the picture could have been the weapon used in the crime. I mean, that's not what we're dealing with here.
Okay, but is it standing for whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence. Do you have case law on that?
I don't, but
maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So we don't have the same probative value here either.
All right. Well, how about we come back to the 14 through 19 portion of this page with the gun.
And I never argued about the first part of 5 to 13. I don't believe I did.
Go ahead.
But it's, again, we got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I'm not following how that's relevant.
Okay.
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs. So from 2015 to 2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for Okay. I am going to permit the 5 through 13 portion in over the objections, and don't find it substantially more prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So, Hall, Hall versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three. 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia.
Appeal.
Oh, app. Okay.
210.
Okay.
And it's 348 Southeast 2D 736. It's 1986.
Okay.
And Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips Court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after is italicized, the prior conviction was admitted into evidence over the objection of defense counsel, because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And to say that he runs around with, I'm sorry, did I interrupt?
Go ahead.
To say that he runs around, he being Mr. Stillwell, runs around with a gun at all times, his conviction is back. It's in this case. Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction's back to like 2012, I think, but I'm not sure on that. I don't want to make that representation.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right. I'll take a look at it over the lunch break and give the state a chance to come up with their own case law on that. And so, I mean, are y'all kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts. Maybe
Okay.
3. And essentially Mr. Copeland saying, hey, he always illegally carries a gun as a possession, as a convicted felon. And of course that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice. Right,
because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
this man is known to carry guns.
This man always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, well, this guy's everyone knows he's the biggest killer of all time, you know, and it's just like, well, that's a problem in front of the jury.
Well, okay. So, I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it up after you've presented whatever you have and after lunch. Because I'm not sure that being able to say, I know, you know, from my own personal knowledge of him that he typically carries a gun is excludable simply because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know, y'all come up with something, hand it to me later. Let's move on to the next thing. We'll circle back on that one.
The next one.
Ms. Hilton, are we in agreement on 213.20 to 214.16?
Yes.
You agree? We're in agreement.
Yes.
That it's out. Okay.
Yes.
All right.
And I just want to confirm, we're in agreement 220, 11 to 21?
I have 22012 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to the half of 15, so we stop after.
Either?
Yes.
Okay. All right. We're in agreement. And then 222.17 to 223.6? Is that what you have as next?
Yes, 222. Yes, 222 last for the 223 last.
All right, let me get to that. Sorry, I was reading the wrong page.
What do we want to do?
All right.
Your Honor, I'm just going by the transcript I have and the number of amount of writing I have on it. I don't know if the transcript, this might be one that we need to hear the
Okay.
audio.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involved in the game was shot up,
Mm-hmm.
and that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all, so I think this is just a big lie. But that being said, the game had nothing. I mean, this is an overt act. The game is a gentleman named, I think his name's Jason Taylor. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter, a number of other artists took sides, and we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game. That, you know, if he comes here, he gonna have to come see me, and he's threatening him.
All right.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them?
Mm-hmm.
And Kenneth says the Game was fixing to get his ass shot,
Mm-hmm.
shot up, and Thug, and would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out
It
of
probably
his,
says if Thug would have told Shannon to do it, because then it says Thug told him no.
right, and he says Shannon told me out of his mouth he was up.
Where does it say Shannon told me?
When you
out of
hear
his-
it, so when you hear where it says indiscernible, so I think the last time we heard this portion, there was a lot of dispute in the courtroom as to what it
Okay.
said, so we need to play it.
All right.
And
I also
we'll believe that's the context that's right.
Okay, but so this is essentially somebody not doing something. Maybe y'all want this in. Well, you wouldn't, but
Right.
Mr. Williams might.
But
So why is it relevant? Because
so it shows that Shannon's ready to do anything on behalf of YSL. Is
All right.
why we believe it's right.
all right.
And that's exactly why it's problematic.
Okay, it's problematic. Why is it evidentially inadmissible?
Well, because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action. And
Okay.
but
Why is that evidentially inadmissible?
because it's propensity.
To say this is somebody who stands ready to act.
Well, yes. Well, not only stands ready to act, but wanted to act. On you know, it's just like
All right.
it's bad character, and it's he's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character, and I think that's the essence of bad character and propensity. Respectfully.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible, evidentially, character evidence to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such tasks or anything that the alleged leader sets.
And Your Honor, also, I'm going to defer to the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I'm hearing was shot up, and if that's what's being said, I would ask that the state provide us with some reports about something happening to the game at some point.
Your Honor.
Because I don't know anything about that.
John, can I add flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him. They did not call Mr. Brian Williams.
Okay.
On their witness list. They stated at one point they were going to call him because we have a short list. And evidence came out that, and I don't know how familiar the court is, but when people are in the entertainment business, they advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool.
Mm-hmm.
So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell is going to do this. There's zero evidence. I've interviewed these people. That the game, it's a band. It's a musical band. Game is GAME. That they were shot at. That they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and a alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah.
And then the gang experts, quote unquote, come in and they say, well, this is what we said and we found out. And I asked, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of a motion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the Honorable Court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act. It was a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as the Little Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Racy on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Racy, it was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks Detective Racy, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site. That vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used. I raised that with Judge Glanville to say, well, how did that happen just now? Judge Glanville would not let me ask Detective Racy about the fact that Judge Staley coerced the plea. It was not a plea. The state comes back after that conference say, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later. And Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing him. And he specifically said, I'm going to trial, except I've been in jail for 5 years and I had the time served set. The point I'm trying to make to you, and thank you for allowing me to speak long time. I didn't expect to go into all this, but it is, you know, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this, portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is, y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, you know, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea. My understanding is, and I read what you had filed, I didn't know that there was anything still pending in terms of anything for me to decide because that's already happened in this case. And even if his later plea was an Alford, we all know that an Alford plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness. But that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County jail. As I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case, so he's not here. We can't cross-examine him. The tendering of an Alford plea or a guilty plea or a NOLO plea. NOLO plea can't be used. So
well,
ignore that.
Right.
A guilty plea or an Alford plea. The person, Mr. Williams, has the right, that's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, O-V-E-R-S-T-R-E-E-T versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 2D 14, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams.
All right.
So
Let me ask you something. So what he is indicted for in this case, this
RICO.
right, this this instant case, that's not what he pled guilty to before Judge Staley and then entered a Galford plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay.
He being, I'm not.
He Winfrey.
Yes, that's exactly
Okay.
right. But, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The juries have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this. When the state is telling you, and I went backwards, I guess, but the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against a co-conspirator, a statement against his interests. He's not here. That doesn't apply either. That man's not on trial.
Okay, so I'm asking what's pending for me to decide.
What's pending for you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you really, why I stood up, I just want you to understand, it is not like this has been proven. The game and that they were shot at, it's just a theory. And I understand you're saying, yes, then they have to prove it and it's up to a jury. I agree with that. But I don't want you to just buy into this is so important because it's already in evidence and the state needs to,
Okay.
Evidence is prejudicial.
All right, thank you. Okay, so I'm not even sure where we were with regard to this.
Play it.
Yes,
We're just,
exactly. Okay.
Your Honor, we're going to start just slightly before at 12:16:45. And this will probably be somewhere around page 222, maybe around line 1.
Well, she not taking no shit. She not taking no shit from nobody. Well, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how does the beautiful game in?
The game nigga is shot up his dog with told Shannon do it. Shannon told me his mouth he was up that way.
Just give me the word.
Yep. And Doug told him no. Say something on the GD, I can't Nipsey Hussey, something like that. He ain't baby. You know what I'm saying? He stopped. I mean, I ain't here to play. You know what I mean? I just don't want to go to jail. I mean.
And we're going to stop it at 12:17.
All right, if y'all want me to figure out what got said, then I'm going to have that tape. I'm going to have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times. So, I don't know.
You want to play it back?
Yeah. Yeah. Not the whole thing, just that part that is kind of hard to, line 19, the game fixing to get their ass shot up, as I think. But after that is what the... Before you hit play, is the sound coming out of that little white speaker? Is there any way I could get any kind of a speaker closer to me? I mean, is that where that's coming from?
I can't, Nipsey Hussey, something like that. He ain't baby.
It may not move far, in which case,
I think that's about as far. Your Honor, but
that's not going to do much. So just put it back where it was. Thanks, though.
Your Honor, I don't know if we can play it slower in evidence review, but I can play it multiple times as evidence reviewer.
Who trying to do that? Him. He not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how does it be for game then?
The game league is shut up. It's dog with told Shannon do it. Shannon don't make probably use up that win.
What I hear them saying is the gang fixing to get his ass shot up if Thug had told Shannon to do it.
And I think it's the next.
Okay.
That's the most undesirable.
Just give me the word.
Yep. And Thug told him no. Say turn on and do it. The game league is shut up. It's dog with told Shannon do it. Shannon don't make probably use up that win.
Just give me the word.
Yep.
Shannon, nobody's something
The
like
game league is shut up. It's dog with.
if Thug would have told Shannon to do it.
Well, how does it be for game then?
The game league is shut up. It's dog with told Shannon do it. Shannon don't make probably use up that win.
Just give me the word.
Yep.
I hear
A theory?
They told me out of his mouth.
Okay, well, I assume that matters. So I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth, so there's speculation involved as well, or, I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, they probably are not doing police questioning thinking I need to establish exactly who everybody. It may be that through this we don't know, and if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the presence of the jury.
Okay, and then with it being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
being willing to do what Bug says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an act.
I'm not sure it's a crime to be willing to do it if you don't do it, unless.
No, I'm saying waiting. Not. I heard waiting, like he was in. I don't know. I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one.
The next one We agree with, based on the court's prior ruling, cover deck, page 231, line 5 through 233, line 20.
I think it should start at 230, line 20.
Yeah, 230, line 24.
Well, 230, line 20 says, this is Mr. Copeland speaking, that car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, Robert. Page 230, line 20.
And where did you say it ended?
To 38, line 20. Really, 239, line 2.
Okay.
All right.
We're in agreement with that.
All right.
Next, I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3, where we get there, to 242, line 21.
That was
It's talk about one of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting, and then there's talk about Tick, who's Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume, rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
okay. So 241, line 1 through 242, line 14.
I have 242 line. Yeah, that's fine.
All right. So y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry. No. And then Ms. Hill, the next one I have is 243 line, I'm going to say 1 because I don't have a line. 243 all the way to 248, line 11.
All All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand, and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
Yes, Your Honor.
And I know y'all are doing the best you can, but try to do better.
So the next one that's not agreed to, that I can move on to, that I think is page 321, line 21 through 23.
All right, let me get there.
So,
Okay. Is the objection speculation?
yes.
So,
I have personal knowledge.
so here, Your Honor, he's repeating, this is a part of that co-conspirator, this is the night of the shooting.
Mm-hmm.
The murder guy in the Thomas.
Okay.
And he's repeating what the Mikian told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mm-hmm.
When you listen to Kenneth Copeland, it's not speculation because this is what the
This
Mikian
is just
told
the
him.
way he talks.
But even when you look at line 24, he says, and when Thug was at Bentley spot, which was more of an affirmative, this happened based upon what the Mikian told him. So this is all in relation to what we argued the other day regarding co-conspirator station.
Where is the state getting that he got this particular information from Mr. Garlington?
Because throughout here, he talks about this is what the Mikian told him when he got into the car with him and explained the murder to him once they got to the car.
I thought when they got in the car, all they had time to say was they shot nut, and then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to Mr.
Sky
Williams'
House or wherever.
And Nard got out the car. And it's our understanding that's when more detail came at that.
Okay, and maybe you're understanding where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that the Mikian told him everything that happened that night. Now, whether
All right,
that
well,
was in the car or not.
I mean, if you show me the part where he says, D told me, what's his name? What's his little D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So, visiting it.
20. All right, so I see if we go up a page on 320 around line 9 through 13, or really 17, 18, that he's at least saying D told me this is all the people that were involved, and he personally knew it because he was with them.
If we go to page 318, Your Honor.
Okay.
Line 10.
Right.
And he says, this is what Little D broke the story down. He said, and then he goes into what Demetrius said, which is all the way leaving the Sky House and said they rolled past him, let outside, they went somewhere, changed cars, and that was it.
Mm-hmm.
I dropped Shannon B off at Doug's house, and he continues to elaborate.
Right. So that's all what happened for him.
Right.
And I think
that's why I didn't object. No,
right.
I'm objecting
So
to co-conspiracy.
I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is. I mean, I guess Lil D broke the story down, maybe.
So, our understanding from this interview is that the breaking down happened in the car.
What doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
Yes, from
Okay.
everything he says to the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here's what he told me. Okay. All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it early, so this is the second time he's telling the story. So for the purpose of this interview, Your Honor,
Okay.
he tells the story initially early on in the morning to Detective Gaither, Detective Dennis,
Yep.
gang detectives, and then later they bring in Detective Thorpe, who was the homicide, and lead detective on the Thomas case, and he reiterates the story again with a little bit more detail in front of Detective
Okay.
Thorpe. So he's telling them all.
All right, and he's already said, I got it all from Lil D. Okay. All right, I mean, I think that is satisfactory, as, yeah, he had a source for this.
The next,
I have 341 to 341, I think 19 to 350, 17.
is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay.
And then 356, 9 to 19 was the same issue, I think.
Yes, I think I have the full redaction, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And Ms. Hilton, the next one I have is 361, line 1 to 362.10. I don't know if he had agreed to that or not.
What I have as the final is that we were going to take out 361, part of line 16 to line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads Shannon shot up that tour bus.
All right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection. I guess the state doesn't agree with that. Detective Thorpe, listen, but you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut. Shannon shot that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on. And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify. I said, because you just said a key piece of stuff we've asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Copeland doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. So he doesn't even respond to Detective Thorpe.
So maybe we could just take that part out then?
It seems right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay. So why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay.
Yes.
All right. Next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on, and then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
365 lines 6 through 8.
$365. Yes, that's in dispute.
Okay, so, Your Honor, on 365, 6 through 8, the context of this is Quindarius Zachary, also known as the other little dude, from Cleveland. He allegedly would buy, he's not a convicted felon, he allegedly buy guns. At some point, he bought a gun for Kenneth Copeland. Kenneth Copeland, allegedly, Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, is my understanding. So
I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Ken. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Thug told him to buy the gun initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary is apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is, this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to when, how did this come about? How does he know Doug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down. Okay, so we'll need some foundational questions on that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it. But we don't know that yet. All right. Hang on just a second. Miss Winfrey. Portion.
I believe there was a portion of, from page 375, line 17 to page 376, line 9. The state only had an objection to page 375, line 17 to 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in, but that was.
I don't have a problem with that. And then 375.
All right, so hang on. So all of 375-17 through 376-9, there's no objection to. Is that right? Is that right?
Coming out.
Okay. Wait, coming out or staying in? Y'all seem to be saying.
Comes out. We're agreeing that it comes out.
Wait, hold on. 375 lines 1 through. You said 1 through 9, Your Honor?
No, I was saying what you said.
Oh, I'm sorry. Yeah. I thought I
You
heard
said
that.
375 line 17 through 376 line 9. Are you agreeing that all of that is in or all of that is out?
I think everything from 375-20 to 370. Everything from 375-20 to 376-9 is out.
Out, okay.
I agree.
All right. All right, what's next?
I have 378, 1 through 8.
You said 378, 1 through 8?
Right.
Yes, that is.
Agreed, out.
No, that's in this.
Oh, okay. All right. Tell me why that's in. Oh, I see. That's not the detective saying 7 through 14. That's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's a comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's going to tell, who's going to give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be admitted.
What's the scope say?
Your Honor, so this is a portion, you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Kenneth Copeland's response, beginning on page 378, line 1, put it this way, Thug and them already knew those 4 right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and it's slipping my mind who's the 4th person. And he says, I don't know about doo-wop, but them niggas not going to tell. That's why they not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least going to make a way to be like, well, Woody's told us, you feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And so who will protect the enterprise. And that's what we believe he is telling them. Like, these people are not going to talk about our activity. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed 3rd 487, which is a 2014 case. And
just tell me that whole site again.
Sorry, and if I went too fast, I apologize. United States v. Reeves 742, Fed 3rd 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this will not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would a jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. Okay. All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think I mean, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have as in conflict was page 386, line 20 through page 387, line 12. And
Is that in dispute?
Yes, Your Honor.
Okay.
I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin, is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like,
And he's referring to is Donovan Thomas. So
And I agree with her.
okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up.
Mm-hmm.
Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purposes of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last part.
But I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah. So when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of
the truth. Right. I was about to say, so now you're conceding it is being offered for the truth.
not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct.
And
Whatever. Whatever.
Okay. But not for the truth of whether he's actually going to holler at him.
Right.
All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in. All right, let's take a lunch break. I know the lunch is here for the defendants, so let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20? 1:20, will that be enough time? I'm asking the deputies. Yep. 1:20. Yes. All right. So over the lunch break, I did not get a chance to do any of the things that I told y'all I was going to do. However, one thing I did do was work on the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals, and I thought a part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say, and to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're going to be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
Anything inconsistent with what Mr. Williams filed yesterday, which I know was part of the file, we would object to. I think that it's important not to say that don't worry about it, Judge Glanville is fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he is no longer the judge presiding over the case. I think pretty much says that.
That's my.
All right.
Can I also ask just a procedural question?
Mm-hmm.
You were very kind in emailing us transcripts like June 7th. Is that, can I ask you, do you know if that's in the record?
It is not yet because it was the rough. Are you talking about of the ex parte?
Yes.
No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Okay, thank you. It's just because we've been referring to it.
Sure.
In an appellate court thing.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers, the only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case.
Mm-hmm.
The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States, rather than.
I am.
Right.
Is that the change you're talking about? Instead of saying I am, say the judge is?
Correct. That, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that.
Okay.
So neither side's happy, so that probably means I did a good job.
Will the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change. All right. So that takes care of that. And we were on I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing yet. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a little.
Okay.
Mr. Shard and I had the ability to meet during the lunch break, and we did discuss those redactions that we agreed with, and there were a few early on that we realized we still disagree with. So the first, Your Honor, is page 266, lines 14 through 24.
Okay.
My stance, my belief is that this goes back to the issue of the hearsay about what he believes, quote unquote, Doug, Mr. Williams, said to other people. And so really the key part of this is the last section. So Doug was like
yeah,
that gun, you know what I mean? And it just
it looks
we need to know if he has
that, yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation. And that also outside the jury. Agreed. All right.
Your Honor, page 270, line 4 through 18.
I stand by my objection to this, but in candid with the court, I can't say the page number, but he previously stated that Mr. Copeland's statements that Shannon was in possession of the gun would be admissible over my objection. I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
So the next round, I think we're back on track, and we're at page 389, lines 1 through 17.
Let me read it. Give me just a second. Okay.
So if you go to just the last line of 388, just back it up.
Yeah.
It says, they're asking who's talking about the Donovan Thomas case. And he said, I never heard Shannon talk about it.
Mm-hmm.
He says, I heard Nard talk and laugh about it. You know what I mean? And he doesn't say what Nard says. So there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible against Nard, who his name is Demise McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen here today.
Mm-hmm.
So we think it's inappropriate to talk about how Nard has reacted or Demise McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right? I mean, the jury's going to know they think Nard did it, that they, the state, think Nard did it?
Well, I would say the state thinks Nard did it. The state in their opening statement has stated as much. I'm standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance, that Nard was there and involved in the car. But, so yes, I would say that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Little Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas, basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang cohesiveness.
Okay.
So now I understand that the state is, the argument for admission is A1B2E. I don't understand how states arguing that Nard, according to Mr. Copeland, saying, laughing and saying, man, F that B, furthers conspiracy in any way. We don't know any of the circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. he better not play with my brother. I don't, we're really leading to conclusions that these are statements in furtherance of a conspiracy. These seems to be individual statements, just what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max does like Mr. Thomas, was mad, but Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and NARS do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be admissible against these.
Okay, so, well, because it's alleged to be a gang and it's alleged to be RICO. And I mean, it's, you know, kind of good in contrast that your client never laughed or said a thing about it. And these people are, you know, it's not true. And you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
Hearing that she's an unindicted co-conspirator?
Yes, I've heard her on jail calls talking with people, but I don't believe I've ever heard that she's an unindicted co-conspirator.
Now you know.
And I believe he did during the entire Little Wayne bus shooting.
Mr. Steele corrected me and said that they have.
Okay, all right. So, yeah, I'm going to let that in.
For Part A, we're complete. I know Part B is probably going to be handled by Mr. Adams, I think. So we have
Part A and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions previously, and then Mr. Adams handled the rest of those.
All right. Take it away, Mr. Adams. So give us the next portion we're going to be contemplating.
Question and go from page 413.
Okay.
To the end of the transcript.
Ooh. That's a lot.
That was good news. And I believe that I'm really just going to be reciting to you what we have already argued, discussed, and agreed to.
All right.
I don't, and Ms. Hilton will correct me if I'm wrong, I don't believe there's going to be any disagreement about what I'm about to go over. But if I can have about 30 seconds just to check one.
Sure. All right. So you're just going to put on the record the stuff that's agreed to?
Yes.
Okay. Sounds good. Pages of lines. Might I ask, if it's already in writing anyway, and y'all can sort out that you do agree to it, if you might just file it instead of reading it out for the next 20 minutes?
I could. What you're actually seeing me flip through our email exchanges between
Okay.
Ms. Hilton and I.
Okay. Well, you don't have to file the emails, but maybe that might be a better use of our time and easier for you.
I'm happy to do that if
All
that's
right.
the court's preference.
Let's do that. Okay.
One
Y'all.
moment, if I
Okay.
can, though. Let me just make sure we agree on one point. speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right. So, and you can just file, I mean, it doesn't have to be in email form. You can just print out, here's what we've agreed to, and file that.
I'll do that.
All right. So what's our next statement we're moving to? Apparently. Mr. Adams got the easy part. Wow.
So we have the statement on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Right.
So this is February 21st.
Yes.
All right, let me get that transcript, and y'all can switch to that video to the extent we might need to ever watch a portion of that video. Nice.
February 21st. My best.
Okay.
Your Honor, and I apologize. Never mind.
Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
For February 21st, the first thing I have is page 13, line 19, page 14, line 3.
Okay.
Do you have timestamps for when you said the page numbers?
So this has 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Okay.
All right. What's our issue?
Ms. Fulton, I'm sorry, Ms. Hilton, could you say now that I have the time, I wanted to make sure we were talking about the same thing.
what, page 13, line,
Line 19 through page 14, line 3.
we've got different transcripts.
So is this with Detective Gaither starting? You have it in your mind? We can't do nothing about it?
Yes.
Is that a different transcript? I can email you what I got. I got whatever I got from Miss Weaver.
Please, Your Honor.
Okay, Laura, can you?
We have different transcripts. I'm just.
Yeah, no, that'll be crazy if we're not working off the same transcript.
And Your Honor, what I'm going to try to do to keep this moving a little bit, I have a transcript provided yesterday by the court
Okay.
regarding my prior arguments about some of these issues, and I'm just going to try to keep up with the transcript and reiterate what I've argued in the past, so it should be the same.
Okay.
And you have the transcript?
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st.
Okay.
2024.
All right. I have that up as well.
Okay, so if I seem to be arguing something that's not consistent with the transcript, please just let me know, and it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context, it is the February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and
Right.
his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe,
and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 401. And it doesn't fall under prior inconsistent statements.
Okay, I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning I didn't have any problem with that. I was happy to tell them what happened.
Yes.
Okay.
And so
if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
Yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
So even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted,
right,
but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in long diagrams.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in, assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
So the next portion, Your Honor, is page 25, line 15 through page 26, line 3.
Okay.
Timestamp 40840 to 40940.
And Your Honor, last time we discussed these, we this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that the, that Gaither says more and more, investigator
Okay.
says more and more. They're all the same issue.
Oh, all right. So y'all said 26 line 3?
So page, no, starting at page 25, line
Right,
15.
line 15 through 26 line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought. This one looks okay also to me. I am going to let this in. I mean, she doesn't seem to be saying we're the heroes. She seems to just be saying, God, tell me something if you want it investigated. All right, what's the next one?
Page 28, line 7 through 14.
Okay.
I'm sorry, the time is 4:10:55 to 4:11:05.
Any additional argument, Mr. Shard, on this?
I mean, it's the same thing. It's just we care about the life of children and those sort of things, and we're trying to put an end to all this. We find that prejudicial.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you. And
All right. Now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through statement, I'm going to overrule that objection.
the next, Your Honor, is page 29, line 9 through, I think I might have I have page 48, line 11, but I think that's a course indulgence, because I didn't do this. So. Okay, I think it's page 29, line 9 through page 30, line 18.
All right, and what's our issue with this? Is this the same concept, or is this moving on to some other evidentiary issue?
Yes. And I believe Mr. Shar wanted it out initially.
This is more side conversation that is, at this point, I don't believe, well, I know our stance is that just because if the state successfully lays the foundation for specific prior inconsistent statements, our stance, my stance, I believe I stand for everyone, speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay.
And here we're just kind of going in talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right. Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm going to play the whole interview, or are y'all?
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I finessed it all. So we're at a position that I don't know if we have to go line by line, because his general statement here in court is, I may have said everything that you said I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case, going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he says, everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if we assume he says that on the stand. But no, you do not. I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video in some way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now, but.
I think we just need to see what he says while we're, well, it says a lot of, we believe two things, not that it's just a prior inconsistent statement, but he's also contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about Thug. They were trying to force me to do these things, and that's inconsistent.
That would be, so this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that, I mean, is that your position?
I think it depends on when he testifies.
Okay, so, yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would not think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position. However, assuming that all of this is going to get used as prior inconsistent statement because of whatever he says, we have to assume it for now, like that's why we're going through this, then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose. My problem is all the talking that's Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator. And I know Copeland said something, so I'm not trying to mislead the court about the transcript. You have the transcript. But I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
Okay. So, I mean, I would think that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29-9 through 30-18. All right. So what's our next slot?
Oh, I'm sorry. The next section is page 47, line 9 through page 48.
Okay. All right, what's our issue?
Brother, we won't object to this motion being redacted.
Okay.
And I think it,
She just said she's fine with it being out.
right, I'm not sure. You said it begins at 47:9 on your transcript?
So I'm taking a note that I believe I got from.
He on his Twitter arguing with Shannon.
Okay, you're right, 47:9. Okay, I got you.
Okay. Next.
So the next is page 65. Line 1 through 5. That's what I had.
Okay. Any memory about why this was objectionable?
I think it may have been the programs that were used that was confusing. I'm looking at the transcript.
Y'all. Anybody know?
Oh, okay, I know what it is.
All right.
This was my objection, because it was, okay. It was, I think it's likely to confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, investigator Gaither is asking, when's the last time that Shannon and Demekion were hanging out together? And when it comes down to it, the answer is, it comes down on page 65, line 5. It says, since they shot at they call. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and
Shannon as shooting in a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at,
but I just have a problem with this being played and putting that perception in the jurors' mind.
Okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes and it gives a lot of context. So Mr. Copeland, in this interview, this is now his third interview that he's had with APD, his second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Demikian and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at the car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car? Because nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it so that we don't confuse the jury. Yes, there is a way to do that, is your answer.
Yeah. Later on in his answer, you're saying, I don't leave the house anymore. I stay away. So I don't think that confusing sentence really adds
anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all can just redact out that part?
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So the rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay. Next.
The next part we have, Your Honor, is page 155, line 1 through page 156, line 2.
Okay. All right. I'm ready for argument.
The issue, Your Honor, is, so, little context. There's a shooting at a gambling house where, by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did, according to Mr. Copeland, no one knew who did this shooting. It was supposedly, and everyone thought it was another group called NBC who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis? Okay. Well, Kelvin Watts was apparently dating a lady named Trevia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trevia that he was responsible for shooting up the gambling house. Then Trevia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. These are, it's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say who did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC, and my understanding is Mr. Copeland was at the gambling house and not at the club, so I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
So I'm not sure what the Sharp saying. He doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right. For that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Antrevia Smith. That's two different people. Gucci Red and Antrevia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
What part of, give me a line number.
Line 17.
Okay.
And if we skip to line 15, it says, goddamn, the next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel, he had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happen after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still hearsay.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, it's the effect on the listeners, which everything that happens after it derives from them knowing that it was Kel who shot at.
All right, so if that's the only objection, then I'm going to overrule that objection. Okay.
Next, Your Honor, is page 173, line 7 through page 174, line 2.
Okay. All right, Mr. Sharp, you want to articulate your argument?
And Ms. Hilton, you said it ended at 174 too?
Yes, sir.
Just trying to get context. We'll withdraw that.
All right.
Yeah, next is page 181, line 8 through 12.
All right. Any chance we can just get rid of that?
Yeah, we
Okay.
have an objection to that.
There we go.
And the last one we have is page 185, line 17 through page 186, line 19. And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement.
Yes.
Okay? What's our next portion of this transcript?
That's the conclusion that we have.
Oh, okay. Well, okay. What's our next statement we're moving to?
We can do February 20th.
Okay.
Send me the same transcript.
February 20th. And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but. I mean, if you're not going to be using it, then that's fine.
Well, I'm trying to remember. I haven't seen the transcript.
Okay.
And February 20th may have been earlier before the break.
Oh, well, hey, then we don't need to rehash that one.
And that's what I'm trying to figure out. But for January 11th and February 20th, I'm trying to figure out when we had those arguments because we actually played those videos on the.
Okay.
Right. We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what day we are.
And those who had the minimal, we agreed on most of that.
Okay.
The actions that came out, we agreed on.
And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. Let me back up so the record is clear. The video for January 11th and the video for February 20th were both played in front of the jury.
So
at least on the 14th and I believe on the 17th of June.
Okay, but
I assume that the argument may have happened
Okay.
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I need to determine.
So I have some notes
Okay.
that were taken by Ms. Haley, who I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 17th. So those were played after the motion. I just want to make sure. What does this mean? Okay. It looks like portions of the January 11th were played before. A very small portion. It was like 30 seconds of it.
Was played before what? Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th statement prior to the motion to recuse being filed? It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
okay.
and this matches my recollection. This Hilton used January 11th as one very particular point that she played like 30 seconds to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed reactions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one, so y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yeah, no, I don't know what that means. February 21st. I don't know. So if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came up. Then when it turned to everything's a lie, then we went to getting in the entire statement. Or playing the entire statement. And so when we had argument.
All right, so you spent a lot of time after the Yes.
I'm looking at notes for 6/17/24. We sent redactions regarding. We were discussing redactions, I think, on 17th regarding January 11th, January 28th, February 28th, and February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just,
So I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense, who knows? I don't know.
So I think the next video we can actually go to is January 28th, because that is where we had some more redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come to agreement. If not, you can either figure out, was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Sean.
Okay. Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all. Mr. Harvey's going to use that later when I say that. Even the judge admitted it. I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes. So,
And that has either not been discussed or it was discussed post-recusal motion.
Discussed post-recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February, January 28th. All right, we can, I assume we have the one that, ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Pursfield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
Your Honor, can we have just 3 minutes? I think we might be able to get through this much quicker. So you're on the first time that we have, we're at issue is page 42, line 3, through page 44, line 8.
Your Honor, that this first segment, it's a dispute. It's a discussion about possible, quote unquote, beef between Buddy J, who is, his name, last name is Usher, and he is allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some ways is that there was simmering beef between Buddy J and Mr. Williams, because Buddy J said some things about Mr. Williams, Mr. Jeffrey Williams, I should say. And Mr. Copeland goes on to say, well, they say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Bloody J, but Jeffrey Williams didn't want Birdman to sign Bloody J because of the feud that they had between each other, and he was blocking Birdman from signing Bloody J. So that's the background. But the bottom line is Mr. Copeland saying they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign and not to Kenneth Copeland. And Kenneth Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on first statement. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were to sign Bloody J, but Mr. Jeffrey Williams did allegedly stop it, they can certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, it's either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of at some point start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Ussery. So when he's on page 42, when investigator Dennis asked, so what happened with Buddy J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying game.
No, it says,
It's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because we have video evidence that at least back in 2012, Mr. Williams and Mr. Ussery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we, that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
All right, and so I understand the objection to that being this, for all we know, is hearsay about why they fell out.
I think it's the way that he speaks, and if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard or, but something that he's.
Why don't we just maybe find that out?
Yes.
Additionally, if Mr. Copeland, outside the jury's presence, and has personal knowledge of it, then that's.
The next portion that is in disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at what we discussed of 80804 all the way through 81150.
Can I back up on one? My notes may be wrong. Did you agree to number 5? 750 to 750?
Yes, we're not going to contest that.
All right, so where are we now?
80804
And
to
those are
8.
the timestamps.
So roughly page 178.
This is a big one. We agree from 80804 to 80912.
Right, and I don't have the
So
timestamps, so.
page 178, line 7 to page 180, line 8.
And the state wants to go beyond that. And what happens after 180, line 8 is very interesting.
Okay.
This is January 28, 2015, at this conference. He spoke on January 11, 2015, speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015 is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder. And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him for the truth of the matter asserted, I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's not being offered for the truth of the matter asserted. It's being offered to show that what Mr. Copeland has said at different times, when common sense would dictate if he's being a truthful person, he would have said what the state's saying the truth is.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this being about any of.
So that's the part we agreed on. And then they want to go beyond that. And starting at 180, about 180, line 8. And we want to keep it in.
Good. So 180, line 8 through what? The state wants off.
Until 186, line 2.
Ms. Dillon, could you just, or you want to stop?
Page 186, line 1.
And the transcript doesn't really.
We can listen to it. And why, I mean, maybe get the gist of it. Why does the state think it is?
Because it's a lot of rumors. This is actually not him testifying from personal knowledge. When he first starts on page 180.
I would concede it's not personal. I would concede that's not personal knowledge.
So think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are is that's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information and being asked about something and coming forward with other information.
Maybe I need to listen to it because I don't really see in this transcript at least, except for on page, the very end of 184 and beginning of 185, maybe. And I'm not even sure if that seems to be the only because they're talking about lead getting killed.
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the nut, the Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in. But the reality is, I don't believe that Mr. Came to the court. I don't believe that Mr. Copeland has firsthand knowledge of that, and that doesn't really fall under my argument about the Donovan Thomas.
Or then you agree that we don't have to talk about that part. So point me to the part where we actually that you, the defense, or Mr. Stillwell want in and think appropriately can come in under the.
I think, respectfully, I think we need to just play it because I can't. The transcript is so long.
Okay. Yeah. No, I mean I think so too. But certainly, it's not that part about Lucci and Lucci's mom. All right, so can somebody?
Yes, so I'm going to start around, as I heard we were at 8:08:30, which should reasonably be somewhere on page 179, probably around line 7.
When she was, she can come out and then like Rich on the corner door had show. And I was there. And Rich on the corner came, but Rich on the corner tried to play both sides. So
He like the guy, like.
yeah, so he just like bro, man, I'm tell you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah. He said like he wanna kill somebody that way gonna hurt. What the hell? Do what he's saying. But Rich on the corner, you born him out of jail. Lucci wasn't gonna pay his bond. They said he mad at Lucci because Lucci ain't paid his bond.
Why? Why Lucci ain't paid his bond?
But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mom's house? Yeah. All we heard was Lucci Mama's house got shot up. Kel pulled up with the guns. Then we come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why
was he there? Who brought him there?
I don't know.
Lucci Mama's house. Kale comes, who brought him to Lucci Mama house? Like, how did he know that got shot up?
Like, do we just hang out in the driveway? How do we? They probably, you know.
So if that's the case, and then he got locked up, why did Lucci want to pay his bond? You know what I'm saying? If I basically
called you and said, yo, my house got shot my town.
Check out.
And then the red Camaro Lucci got, the same color that ran around, they shot my girl mama house up. They Lucci color. You know what I'm saying? But I ain't get it. Like, you know what I'm saying? They got my name on so much stuff. Like, people that come and tell us, they tell us little bit, then they start talking about it's me. You know what I'm saying? Like, my girl, she get a lot of information from her friends. She got a lot of friends, so they get around with me. Lucci and them was talking in the studio, and there was a girl in there that missed one of them, and she my girlfriend. And she said that they nobody didn't do that. Nothing. You know what I'm saying? They was all like Kill and K Rob somebody. You know what I'm saying?
Kill and who?
K.
Who's K?
I sent you a picture of that too then. I think I sent to those each other. They had Chop on in the picture. Oh, yeah. And the them was in the car. Yeah, them two, Rob somebody. And they supposed to came back. This was they talk about in the studio. You know what I'm saying? They just put my name on it. They covered it up. Make it seem like they ain't got beef in the streets, whatever. Yeah. And then they like, she be like, they know we can't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nut got killed, K first one called everybody like, we killed Nut. We killed Nut. Tell mom now we did. He the first one started my name. And they like, Kill went along with it. So they had Judge Ural Glanville, then they did, like, Nut died, then they started. That same day? I don't know when. They like, they Judge Ural Glanville. And they supposed to be coming back for them. You know what I'm saying? Like, Kill Rock Fly, Plug, Fly. He robbed one of them. Like, and then, like, they would have, somebody broke in that car. And gave me the phone. And the jury.
Stopping at 8:11:50. So, Your Honor, and looking at a lot of it is these just rumors about what he's hearing about what happened leading up to the murder.
I don't even know if they're rumors that he heard. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that that Kel and Kay robbed someone, and then those people came back and killed Nut. And that is, and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the room, is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to the state's theory, Mr. Copeland had inside information on January 10, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility, but the state is arguing that there is credibility with his June 10, 2015 statement, and we're saying there's no credibility to that either.
So that's what I'm saying, Your Honor. I don't think the two are not mutually exclusive. He can know the truth, but proper rumors, but what those rumors are is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation. It's all rumors. And he can they can clearly ask him that on the stand without going into.
All right, and I assume that the only reason June 10th comes in anyway is because he takes the stand and says, I don't know anything about anything, I don't remember. Right, and so June 10th comes in as a prior inconsistent statement?
Yes, Your Honor. Because prior to everything, his response is everything in June 10th, again, the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changed some of those facts. I don't know what he will do when he comes back, but that's what he can do.
And so the defense, if the state can stand up and go, all right, here's your prior inconsistent statement where you said X, Y, and Z, which was all of these people over here on this side of the room killed by, then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
I think they can ask him about, in January you said it was all rumors. You said that. You said that there were rumors. What those rumors are, I don't think is relevant. They can definitely ask him. Now, whether or not he says, I never gave anyone a rumor, then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there would have to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand, you told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
We've all been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail. No, it'd be one thing if he just said, John, I heard John killed Donovan Thomas. But he didn't do that. In this story he gave, he gives details. He gives a story, a coherent story. And that matters. It's not just that he gave rumors, he gave a coherent, detailed theory. And the state, I'm sure at some point, is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. How would he ever come up with this story that it was these specific 4 gentlemen in the car? How would he ever? And we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say, oh, well, you talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's going to depend what he says then.
Oh, well,
whether.
Well, okay.
Oh, me? Yeah, sorry.
So maybe if you're saying, I'm not presuming that he's going to deny saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th, he told about
this
all
story
that stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily get
Yeah.
to play.
Okay.
But I think, as I understand it, the state's saying that we don't even get that to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th.
They can ask him about that, right? I mean, you agree to that.
You're asking if he can say, this is what I told the police?
Can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt.
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the street. Whatever the rumor was, to me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people did. You only proffered rumors, not the...
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
That is not correct. You can, in fact, ask them about the detail of the rumor that he told them. As long as, I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's going to be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
That's fine. We still believe that the rumor is speculation, but we
No,
understand.
it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor. That is not their point. Their point is you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but they can get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Right. I think what you just said is what I want to ensure that we're
Yes.
going to do. So
Okay.
I think we're good. And Your Honor,
He's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
the one position is, you may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was,
I said all of I don't remember exactly what I said, but everything I said was a lie, right?
exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this
Yeah.
murder, and I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, Mr. Lamar is Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
All right. What's our next portion of this transcript at issue
The next,
or statement?
the next part that's at issue potentially is page 203, line 11 through page 206, line 17.
Okay.
And more specifically, page 206, line 15. To line 17. Mr. Shaw, are you okay with 82131 through 82137?
So that's 206, 15, and 17.
Yeah, that's going to be page 203, line 1 through 16.
Your Honor, could I just ask that 15 seconds or whatever that is potentially in dispute be played? Because I don't think I have an objection, but
Okay.
I can't really tell from this.
Okay.
If I could just hear it.
Sure.
And Your Honor, I'll play with 82131 to the whole section.
Okay.
Me and G together don't matter what. Just like GP. We work together. You know what I'm saying? We not doing that.
Who killed DB?
They don't even, man. They don't
Who
even.
you think?
I don't know. Fred.
DB.
They don't even, man. They don't
Who
even.
you think?
I think you started right after the
portion.
Yeah.
Man, besides Shannon and D, you ain't gonna see me hang with nobody.
So is it a person?
No, that's what I say. How the hell I be eating all the time? Everybody else to eat. Like, it's not one time.
I'm fine. The state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 82137 to 82252, where the murder of a gentleman by the name of DB is discussed. I believe that we agree that is coming out.
Okay.
And then if Ms. Hilton would just play the 7 seconds that on the other end of that she wants to include, I just want to make sure.
All right. So this is going to be somewhere on 206.
Yes.
Okay.
We're starting at line 5 or line 6.
Okay.
It's going to start a little early at 822:02.
Okay.
He just showed up. He did kill me. It was his fault. I know, but just like you said, somebody, it ain't like I put him on the team. That's about what we can prove. But, just like the little nigga, Lil Haiti. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, Lil Haiti. You know, who's supposed to have something to do with GB. Oh, okay. But that nigga walked up on me, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me by himself, like, I know that's my little brother, Lil Haiti, he just got out. So I'm like he booked, like, nigga, shit up. Nigga, like, what's up?
Hey, Lil Haiti the one that got shot in the face?
Yeah.
On Boulevard, right?
Yeah.
He out too?
That him. Like, I don't know. So some corn got a video on his page. All them walking in the house. Same night he shot my grandmama's house. I know them, all the niggas they did. You know what I'm saying? They pulled up into a house with 3 cars.
So you mean, after this, so it's Rich Homie and Thug beefing?
No. How is that not possible? Everybody try to say. I feel like
he playing both sides.
Nah, I feel like everybody like I feel like don't fold when he needs. Nah, I feel like they came together and made an agreement to kill me and everything go away. I feel like it, but I'm not gonna run.
Even
portion we can keep out.
All right, so what is the portion that is at issue?
No, nothing now that.
All righty, I'm glad we all did that.
Page 2259 is where we're going to go back live on the state.
Yes.
It's played.
So the full redaction be 82137 through 82259.
Sorry, repeat that.
Sorry, the full redaction will be 82137 through 82259. And that's going to be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree. Is that correct? And it's only apartments.
Okay. Where's that one?
Page 269, line 19 through page 270, line 14.
All right, and is this the part that the state wants in, defense wants out, or the other way around?
If I can do one more time, this might.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Doug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this, and that was our disagreement.
We are fine taking out that part.
That part being.
Sorry, what Mr. Sharp just mentioned that Doug did.
Okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said Doug as had something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well,
So, (269:19 through 23), where he's saying some detail about what he heard about not getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that is out. My understanding was the state viewed that those timestamps were too large and that something within that time period can get in, but
Okay.
maybe not.
All right, Ms. Hilton, was that something y'all intend to put in?
Initially, yes, but Your Honor,
How about now?
we will not put it in.
All right, so then 269 line 19 all the way through 270 line 9 is I'm sorry, 9 or 14 is out by agreement. Which one was it? The end, 9 or 14? No. Okay.
So, Paige, you told me line 9.
Line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way?
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super. Just get together with your colleagues on the other side and make sure they agree and get it filed. Okay, so that's that statement. That's the January 28th statement is taken care of. And y'all are gonna, on January 11th and February 20th, figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
You wouldn't do that. That's what we did this morning.
That was,
You started with June 10th.
We'll go in reverse.
You went in reverse.
oh, right, okay, you're right. So if we've done
all the 3 that we can do.
And, okay, and then the other 2, y'all are just gonna figure out what the small little differences are. Okay, so then I think the next thing we have to sort out is with regard to the testimony of Mr. Copeland that occurred post-recusal motion. I don't know how many days of transcript of that y'all have yet. I think you have at least 2 or 3 days worth of that, but maybe not all of it from Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some through Ms. Firstfield. Because, right? Have y'all discussed that at all yet?
So Mr. Shard and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay. So over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what, of Mr. Copeland's post-recusal motion testimony, there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony, you know, just what we're going to tell them about that. Okay. And then after Mr. Copeland testifies, what's next? And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's going to do.
That part is true. Does the court mean like which witnesses?
Yeah.
Okay, so I anticipate there will be 2 other potentially Mr. Sledge, Mr. Zachary.
Okay.
Those two.
This is what you gave me. That's basically an order, right?
Yes.
Okay.
Yes.
So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to give us all the details about the evidence?
You said the exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 might have been Monday.
the first 30
Okay.
Monday.
All right. Okay. So I honestly did not think we would. I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So this is a good time to adjourn for the day, or do we have other things we want or need to take up right now?
There may be one more thing that we can
Okay.
take up if the court would allow us one more.
Your Honor, we do have the 5 jail calls that we intend to get in through Mr.
Perfect.
Copeland.
Yeah, we can do that. Okay. And I've already listened to the portions of.
And there were portions that we did not object to, Your Honor, so I can go through by call which one we didn't object to.
So you're working off of, so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes. Is that what Mr. Steele sent? No. For the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. What I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And it says forward Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I have.
Well, give me what it is that I need to be looking at.
I can find it for you.
You know what? What I'm looking at right now is not even about the jail calls. So never mind. But I don't have what it is that you're talking about.
I'm looking for it.
So there
I just
are 5 jail calls and there are portions of the 5, is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yes, so the
All
state's
right.
intention was to play the entirety of the calls, but
All right.
then there were some objections, and so
Sure.
we don't have any objections.
Okay.
So we don't have objections.
All right, so do you want to put on the record what portions?
Well, you're asking me to do that?
As if the court has the email, I can go through the areas where there was objection. And
I don't have the email. I do have the email. I just don't know where to find the email. Okay. All right. All right. I am now looking at the email. So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50, and the state has no objection to not playing that portion of the call.
Okay.
From 15:15 to 15:32, the state has no objection to stopping, to not playing that portion of the call. For the June 10th call, from 7 minutes to 7 minutes and 3 seconds, we have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from
Okay.
9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13. And then for the June 15th call, we have objections to 4:53 to 5:11.
As in y'all want that in?
Yes. You're
Okay.
right. 6:01 to 6:12, we object. We want that part in.
Right.
6:42 to 6:49, we want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17. And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay. I wrote it. I have it handwritten.
Okay.
So, because it's on the back side of
All
it.
right.
So we have no objection to 13:10 to 13:17.
Okay, great. All right, so then our issues are with June 13th, 2:55 to 3:10. And then June 15th, 4:53 to 5:11, 6:01 to 6:12, and 6:42 to 6:49. Is that correct?
Yes, Your Honor. And so we're pulling those 2 calls up now, Your Honor.
Okay.
You heard me live?
As Mr. Box is here and Mr. Steele is handling this portion, may I step out for a
Sure.
second?
This is a free call from.
And I'm going to start, Your Honor, around 2:25.
He booked the Brandon.
Meet me on University.
On University where?
At that gas station we always, you know what that gas station, Chevron, that Chevron. Meet me at Chevron.
Hey, man.
Okay.
Yeah.
That little D ain't right, bro.
What did D do?
I'm gonna say too much, bro.
The D told. What's that? You talking about rock crew, Lil D?
Yeah.
I told him. He told on Roscoe too. You think I'm fucking playing, bro? He told on Roscoe. He told on Roscoe just cause he Roscoe ain't no fucking blood. And he don't give a fuck. Roscoe ain't free. Hey, D Sean, I'm finna come meet you.
And that concludes at 3:11, Your Honor. And to give some context, on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Miss Quarterman, who then calls the person who you hear is Max, but is also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members were called to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion of the call.
Okay. And the objection.
Your Honor, it is not, I don't know, I've listened to these so many times, I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this isn't appropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
Yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it from?
Well, I don't know that matters, because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering it whether D is or ain't right. It's the fact that literally it was everything they said about him, and overtly the fact that a YSL member, they believe, told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people, still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent for the government. He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you. That's in the recording that you listened to. You didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. and it is being asked for the truth of the matter, because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you can think of.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
If they lay a foundation, then I
And I don't know what that's going to be, but assuming, I mean, I don't know, maybe you want to elaborate, Ms. Hilton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially, it would be a co-conspirator statement between these co-conspirators talking about gang activity.
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
Your Honor, is of course I would just start at 450 and play through 649 because it's only about 2 minutes for those 3 seconds.
I'm still sitting on the phone.
And tell me who I'm about to hear.
Yes, Your Honor. And Casa, this is again Mr. Copeland calling his girlfriend on 3-way, but at this point he has asked his girlfriend to call Detective Gaither, and so the portion that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay. I'm
going to start at 4:47.
Everything. Like, I'm not going to sit here and promise you, like, you're going to get out of jail next week or in 2 weeks. All that. Like I told you, you gave us a lot of good information, but we got to still do our job. We're not just taking your word for the gospel just because it's coming from you. We still got to investigate shit. So all of that will be taken into consideration at the end of the day.
So my brother,
like I said, do your brother know what?
That federal put the feds could charge him.
I'm not talking to nobody about your case, but to you and who you got on the phone. Yeah. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told what the ATF agent when we first came in, the lady.
Yeah. That's
what we did in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then you gotta let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state judge and
And I concluded at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements, bolstering so far. You've helped. We still have to corroborate, but so far this was helpful. I don't know what the right word is. And I believe that that's bolstering his statements.
All right. And what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand. But if he goes down the same line of, I was just lying to finesse investigation, I made it all up, this is in complete contradiction to that, because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again, because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until...
Well, he's not really saying anything over again. He's saying, hey, I told y'all something. Can you let me out now?
Right, and so when he's saying everything I said is a lie. So
he is now, yeah.
He is now. So what this shows is a contradiction, because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie. Especially when she's telling him.
All right. The objection is that Detective Gaither's statements, well, yeah, I mean, you seem to have helped us, but whatever. Why do you want any of this?
Well,
how do you envision using that particular thing I just heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate anything. Okay. That they took his version and just ran with it.
Okay.
So this supports that that's not what happened. That even back in 2015.
Is Detective Gaither going to testify?
She has
All right.
testified.
Has she said already, man, we didn't just take his word for it, we investigated?
She testified
Yes.
to that.
Okay, so it's not necessary for that.
But again, I think it gives context to, while Mr. Shields focused on Detective Gaither, we're focusing on Kenneth's actions, that if he lied, he would not continue to call the police to verify how they're going to help him. When he knows, listening to Detective Gaither, every time she speaks to him, she says, we can't do anything yet until we verify what you told us. So clearly what you told the police isn't a lie. Even though you're saying that today in 2024, what you told them back in 2015, you believe to be true, because you wouldn't keep calling if you just want to tell them one lie and that was it. You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for, is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now. Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is, I got to verify this stuff? See what you can do, okay?
We can see what
Okay.
we think will be out of power.
Well,
We'll see.
I don't know.
Judge, if I may.
Yes.
Again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously.
The state's position that he just put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying. He said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hilton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can.
Yeah,
It's not inadmissible for them to try it.
no, I understand. But I think our objection, as Mrs. Steele stated a little while ago, is, why is any of what the detectives bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident that she can.
Let's have it. All right. Okay, so that is all of the jail statements.
Yes.
Okay, super. All right, one thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it that y'all are doing this? Do I hand these out to all of y'all and then? All right, I don't need to, oh, y'all have them, so.
We need the base.
Okay, and I mean, everybody doesn't have to do it. If a couple of people want to.
That hasn't been plugged in
No
and made
earthly
a
idea.
charge right now.
It's plugged in right now.
Okay.
So I take one of these too? Is there some significance to the red ones?
You want one to try?
Hey, is there some significance to the red ones? Does anybody know whether there's some significance to the two that are red?
I don't think you've ever used those.
Oh. All right, so. And does the court reporter get one so she can also hear what's going on, I would imagine? Okay. And then what?
There's a push to talk.
Sorry, y'all. Yes.
I have
We're done with court for the day, so you do not need to video me trying to figure out the technology.
that was the easiest request, Your Honor. Clarify that.
Can I make one more statement before you adjourn?
Something we need to put on the record.
Yeah, we can
Yes.
use the bench if you want to use your
Hey, that's a brilliant idea, because they don't take pitch conferences. Sounds good to me. All right, but how do you turn this here?
This will be
Yeah.
brief, but Your Honor, important to us and to the court. On February 7th, 2023, on April 18th, 2023, September 6th, 2023, January 13th, 2023, and one more, and then, which I don't know the date, July 29th, 2024. Mr. Williams has put in Brady motions,
Okay.
and the state has not complied with Brady. They comply at times. I'd like a date certain, like today, that any Brady evidence that is still outstanding, that it has to be to us by Monday or whenever you think, Wednesday, whenever, because Brady is, so serious, because then we go out and investigate, but the witness is already on the stand.
Right.
So I've, I know I don't have to put in writing. It's not good faith or bad faith. It's a prosecution team. But if the court can just set a deadline, and then obviously it's ongoing because new information may come forward. That's my only issue.
Okay. Is there anything that you, know of that you don't currently have?
No, because then I'm not so sure it'd be Brady.
It wouldn't be, but people refer to stuff as Brady, even though it comes out and you have it for the trial.
But anything, Mr. Zachary is a perfect example. I have no evidence of this. But if he's coming to testify, the state has alleged that he's a co-conspirator, unindicted. There has to be some sort of agreement. I mean, there just has to.
I'm sorry, some sort of what?
There has to be an agreement.
An agreement. Oh, okay. Well, a lot of times there's not any agreement.
Okay.
There might be.
But
I would
just use that as an example.
I would hope that the state knows that if you have an agreement with any witness about, you know what I mean, more lenient treatment, any kind of an agreement, that you need to reveal it. You know that, and you will do that. And you will do it as soon as you know it. If one does not currently exist, but one develops next Tuesday, then tell the defense next Tuesday.
We will.
Okay. And as to any Brady material, and understand your obligation is to everything you know right now that is material, potentially exculpatory, anything that could be covered under Brady, you need to provide to the defense if you have not already done so. And I'll let you make a statement if you would like to after I finish talking. And the Brady obligation is continuing. So if y'all are still doing any kind of investigation, you come up with anything that is Brady material, then you also need to get that immediately to the defense.
Yes, we understand that.
Okay.
And
All
we
right.
will continue to comply, and we will converse. And if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay. Thank you.
Thank you, Your Honor.
All right. See y'all at 8:45 on Monday. 9 on Monday. Yes, Mr. Short. Let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to sleep. 9 o'clock on Monday. Yes, sir.
Your Honor, I just wanted to bring it to the court's attention that I know that Mr. Weinstein has an outstanding motion that he renewed maybe 48 hours ago.
Which was...
You might confirm about my mistrial?
Yes.
Oh, no, I know. He has a supplement to that, and I thought I said this morning that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
as
have
we
more
head
to
into the
add?
week. Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
He is.
It's very kind of you.
Welcome. So I recently filed while we were in court, a motion for a fair trial seeking remedies. Oh, and I will email, it was just filed, and I will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
which matters?
The ex parte communications and the impropriety.
Yeah, like wanting to cross-examine yes,
Calling
wanting
John
to
Melnick.
put Mr. Melnick's testimony, and yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
y'all don't want to do just a proffer.
Mr. Steele was the Spoke to Mr. Melnick, but yeah.
Okay. All right. So with regard to the motion, Mr. Shart, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what your Honorable Court said. He stated that it was very nice. He said that I does not get his permission for him. He'd like to address the court himself. I said, okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told
Okay.
you.
What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I have not finished reading all of the material and all of the case law, so I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So, under CAR, C-A-R-R versus State, it's a 97 case, 98. It was the case that the gentleman who owned Pike's Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to they carry the burden. They can charge people. They can ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself because he said that what the state was saying is not accurate.
Okay.
And I think that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, and I'm not picking anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretense.
Okay.
Mr. Melnick is going to say that what Adrian Love said to the judge is just patently not true. Via emails, her description of the emails is untrue. And there's no way to say that's inadvertent because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's
All right, well, the best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody give me the emails.
I did. I put it in my motion that I filed when I found out this Honorable Court was the court. And I forget what I titled, I could find out for you. But
Okay, I'll go back and look at those.
it was a motion, it had two parts to it. And it said, I really don't want, as I told you, I don't want a mistrial. I just want to make it right. And I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you make a credibility determination, Adrian Love, John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript, so Mr. Weaver is either not there or definitely not reporting it, that Mr. Copeland did talk about the killing of Donovan Thomas, that it's not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean, you are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Ms. Bumpus talked privately, which obviously nobody recorded because the court, at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record, and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Ms. Hilton, or I think Ms. Hilton, Ms. Bumpus, and Mr. Copeland could talk together.
That's the part I'm talking about. So it's not privileged.
Okay. All right.
That there was substantive conversation about the killing of Mr. Copeland.
Okay. So
And Ms. Hilton.
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
Impeachment.
Okay, impeachment. Okay, and therefore Brady. Okay.
So that's why I wanted to put.
All right, thank you.
And call the prosecutors. Now, they may say that didn't happen. And I assume that's what they're going to say because they would have a Brady obligation to run out and say, June, this happened, this man said this. But they didn't say that with anything. So I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady? Because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that, so.
But I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right, and that's why I asked you to have an evidentiary hearing.
Okay.
I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged, that Ms. Bumpus, Ms. Hilton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Mm-hmm.
He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th, and I did not get that from Ms. Hilton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to call the witnesses because.
All right, well, you didn't tell me that before.
Okay, well, I didn't mean not to tell you that, but I was trying to be open, but that's the reason I wanted to call witnesses.
Okay, I mean, that's, okay.
additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know. That's a part of Mr.
Right.
Weinstein's motion for mistrial. Yeah.
And you know, I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns. But Mr. Melnick can explain, you know, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
And I think that's important for the court to know.
Okay. Well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte, because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Can I respond to that?
Yes.
So, as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that and they were going back there to have that other conversation. So that's
okay. Yeah, I mean, I know y'all didn't know the substance of it, but.
And wrapping back around to that.
Yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that occurred as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No.
Okay.
So we submitted a motion.
Right. And they have a copy of that, and that's,
Right.
all right.
Right.
Okay.
That was,
Okay.
and Judge, I'll also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I think.
You could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay. Well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right. Well, Mr. Shard, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but okay.
And Your Honor, so that we are, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for.
Maybe.
Would that be a collateral issue?
Maybe.
Okay. So
if I end up hearing from the two of you on that, I'm not gonna make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
And okay, and so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday. All right.
One last thing, Your Honor. On Tuesday, I believe I brought to the court's attention whether or not the court would allow, if we get to Mr. Copeland next week, I know you said the jurors might not come back until Wednesday.
Right.
Substitution of counsel, and wanted to see if the court had made a decision or a ruling. But one objection.
Yeah, I never got any kind of written anything or further objection from anybody. So I think there's just the one objection that I didn't get a real good reason for. Okay. Yes, there may be a substitution if we end up examining him while you were gone. Thank you, Mr. Weinstein. All right. We're actually in recess now.
Thank you, Your Honor.